Okay, hello everyone, and good morning to all of you. Welcome to this new class, new session of Indian Constitution. And in the last class, we were dealing with fundamental rights and other other features of the fundamental rights. So today we will continue from wherever we have left, and then we will continue with today's new topics. Okay. So first of all, let us just see through it what we have done and what we haven't. So we have done about with the fundamental rights. We have done with various articles. We had done with the features of the fundamental rights, and we have also learnt about the 6 categories of fundamental rights. Okay. So next, there are certain articles which we have done about article number 12, where we have defined the definition of state. And if we are talking about the definition of the state, this definition stays for absolutely for the whole constitution. This is something which we need to understand. That means whenever we are coming across any of such things any of such definition of states, so we will be talking about this particular thing only. These are the definitions which has been defined in the constitution, and we will be talking about the state in the whenever we talk about state, it is all about the which bodies which we are talking about. We are talking about the local bodies, we are talking about the government legislatures, and at the same point of time we have certain private organizations as well. Okay, so next we have talked about what are the laws. We have talked about right to equality, and what are the various things in equality we have talked about. We have talked about the exceptions. We have talked about who will be getting opportunities in the public employment. We have talked about Mandal Commission case. We have talked about untouchability, abolitions of title. We have also talked about in our 2 classes back. Then we talked about right to freedom. What are the various rights under the freedoms are concerned. We have talked about the 6 rights which are being guaranteed under Article 19 in our last class. Okay. So next we have talked about when Article 19 can be restricted by the state, and all these things which we have talked about. Next we have talked about what are the things which will happen when there are certain conviction cases, and all these things are being dealt with. Okay. Next we have talked about personal liberty. Then we have talked about what are the protection when any person gets arrested or any person gets detained. We have talked about it, and we also have discussed that the person who is being detained or arrested in custody should be produced in front of the district magistrate, nearest district magistrate, within 4 hours of arrest, excluding the time necessary for journey from place of arrest to the court. So that means the journey time is not being considered, but from the moment he has been arrested and till the time he is being produced in front of the magistrate, the total time should be less than 24 hours, or maximum 24 hours should be there. Okay. Next we have talked about rights against exploitation. We have talked about prohibition of human traffic, and we have talked about prohibition of employment in children in factories and other mines, whatever it is. So we have talked about the forced labor, which is known as begar, and we have talked about trafficking, which is buying and selling of women and men, children like goods. Means we cannot consider human beings as goods, and that is what human traffic is all about. We cannot sell human beings in any sort of market. Okay. So Devadasis I have talked about. We have talked about slavery. We have talked about immoral of women and children. These are the things which are prohibited under article number 23. Next we have talked about prohibition of employment of children in factories. We have talked about that below the age of 14 they should not be employed in any hazardous activities like construction work or railway. And also at the same point of time I have linked this article 24 with article 19 where and article 21A where there is right to education has been mentioned. So we have talked about this as well. Okay, so next, right to education is 21A, that is we have talked about. And article 21, what is the link between article 21A and article 24? They can be interlinked. I have told you this thing in our last class. So today, in the next part we move where we have learnt about freedom of religion, that any person can practice, profess or propagate any religion of his choice, and it is basically the freedom of conscience, okay, and freedom of profession practice, which is written in article number 25, and to manage religious affairs. Then we have got freedom from taxation for promotion of religion and attending religious instructions. These are the 4 articles which we have talked about. And in the next we have talked about who can and whatever, who can propagate the religion, who can practice any religion, all are written under article 25. In article 26 it is about managing of the religious affairs. That means, and yes, I have also talked about the infamous Kesavanand Bharati case where article 26 was in contention, and it was basically of this third part, the right to own, acquire movable and immovable property, because right to property was struck off from the fundamental rights. So, and there were restrictions in whatever the property a person can hold, but for religious practices or religious organization, this rule is relaxed, and they can have property. And this is what I have told about. This is the third point where they can move and acquire. They can acquire movable and immovable property, and this is about article number 26. Next, freedom from taxation. There should not be any taxes. I talked about a famous tax which was prevalent in the medieval age, which was known as jizya tax. Okay, which was known as jizya tax, and it was the Mughal Emperor Akbar who abolished this tax. And as per this tax, what happened is the people who the Hindus, they used to pay taxes for pilgrimage because it was a Muslim dominated empire. The ruler was Muslim, and it was started by the rulers prior to Akbar, and Akbar decided to remove this tax which was known as jizya. And basically this kind of tax are known as religious tax, but they can levy a fee for some special services, safety measures, and all. I've talked about this thing, like we have sometimes in the Amarnath Yatra there are helicopter services, there are tent services which you need to pay because you don't have any place to live, so that will be the time shelter, and for that minimal fees are being required for the maintenance of the place. So that is why that fees can be levied. I talked about the subscription, the chanda during Durga Puja or any sort of puja. That is something which is allowed in any religious practices in India. Okay, so next we have talked about freedom from attending religious instruction. That means any person can attend any educational institution which is only maintained out of state fund, and it is a religious institution. Okay, it is a religious institution. Like we have talked about the madrasas. So these religious institutions can be attended by the people, and nobody will be as forced to stop him, or nobody can force anyone to go to those kind of institutions. And if the person is minor means below the age of 18, the consent of his parents are required. Okay, the consent of his parents are required. So till this topic we have done in our last class, and today we will start off from the new topic which is known as the Article number 29 and Article 30, which deals with cultural and educational rights. So, cultural and educational rights we will today study. And the first article we have got the protection against the interests of the minorities, and Article number 30 says the right of the minorities to establish and administer educational institutions. See, in the last article, article number 28, a person is free to go to any religious instructions or religion based institution for studies. And see, in the article number 30, it is said that for the minorities, they can establish and administer educational institution. We have talked about madrasas. We have talked, and in this place there is another which can be said as the convent schools. You must have studied in convent missionary school. So these are the place which we can say that these are controlled by the people who are associated with Jesuit foundation or certain kinds of churches where they provide education, and at the same point of time they propagate philosophies of the Christianity. So these are the things which our country allows for administration of the education institutions like this. So, and many of us, even I have been to a convent school. So this is something which is absolutely allowed in our country. But the thing is that these convent schools cannot force the students studying in their schools to convert themselves into the other religion. That is not allowed in our constitution. You cannot force a religion on anyone. Okay, so let us talk about article number 29 in detail. Okay, so what does article 29 says? Under article 29, it says that any section of the citizens residing in any territory of India or any part of our country having a distinct language, script or culture of its own shall have the right to conserve their culture. Like we have in this part of our country, that is West Bengal. Yes, we have a culture of the Bengali culture we have. But if you move to the interior part of the Bengal, and you will find that they have got a special culture which we are not aware of. These are the cultures which are something which is about the tribals we are talking about. As minorities, if we talk about, under the minorities, the tribals, race, they caste, they are also considered minorities. Means a language which is spoken by very few. That community can be said as linguistic minority. If we are talking about a particular tribe which is having a population of say about 500 and it is not found in any parts of the world, they can be said as racial minority. So these are the things which we can say. Yes, religious minority, we already know about it, but minority does not mean that it has to be only about religion. Okay, we have to talk about race, we have to talk about the caste, we have to talk about language, that means linguistic. So those persons of that particular community have every right to conserve their culture, conserve their language, conserve their script, conserve their culture. These are allowed, and they should, if they have to pass on certain laws, that is also allowed. Like you say, I have talked about a community of Jarwas in Andaman Nicobar Island. We have talked about certain even in West Bengal, if we talk about, we have a tribal group which is known as Toto, not the Toto which you go around the city or wherever you live. Not that Toto, but yes, Toto is a community which lives in the North Bengal, Jalpaiguri district, Moinaguri, and all those Lataguri belt we have. And for them, this Toto Prajati, Toto tribal group, they have a special village which is being conserved by the government of West Bengal, because they slowly coming down, and certain persons of that particular tribal group, they are coming to they are trying to come out of their culture and mingle with the mainstream culture. But at this point, by this, what happens is the actual culture law is getting lost. There maybe they have certain different types of language which they speak, that is getting lost. And in this way we have actually lost many, about 150 languages in last 10 years, because they did not actually, or they did not do any kind of protective measures so that they can have their language, script or culture conserved. These are the things which are happening day by day, and for this reason we have certain restrictions, we have certain rules which allows us to protect our language, script or culture. Next point, no citizens shall be denied admission to any educational institution maintained by state receiving aid out of state on the grounds of religion, race, caste or language. Well, this is also the same thing. Means if I am from this particular West Bengal state and I go to study in South India, they cannot say that, okay, you are a Bengali, we won't get you admitted over here. Or somebody said that, okay, you are from the Brahmin community, this is for the lower caste, so you are not allowed over here. Or you are speaking some different language than us, so you won't be getting admission in our educational institution. And it is all about the state. And again I am telling, the state may be a government or a private institution, and private institution means receiving aid out of state. That means they are being funded by the state government, or they are absolutely private individual. But these are the things which they are not means they should not get denied their admission, or they should not be getting denied on the basis of their rights of speaking different language, following different religion, or from a different caste. They should not be denied admission. Okay, article number 29 also grants protection to both religious as well as linguistic minorities. Yes, I have already told this in our first point itself when I was explaining this. Okay, so these are the things which we have. And at the same point of time, the Supreme Court said in one of its judgment that the right to administration is not the right to maladministration. The university can put basic qualification for selections, but that should be purely academic, not based on religious, race, caste or language. Okay, so these are the things, and it is applicable to both the teachers as well as the students who are seeking entry in an education, either for teaching or for study. Okay, so these are the things which article 29 of our constitution has put down, and these are the protection of interests for the minorities. Okay, just a minute, this is actually article number 30. Okay, so there is a small mistake, this is article 30. So article number 30 basically grants minorities to establish educational institution. Well, I have already discussed about having a convent school. Okay, convent school, they are being established. Then there are certain madrasas which are being established. So these are the things which their minorities have the rights to administer. Even if we talk about the linguistic minorities, they can also open any educational institution. Like in the state of West Bengal, even in Kolkata we are talking about, there is a school which is known as Andhra School, and it is a state funded school. And Andhra School is for the communities from the Andhra Pradesh, and they can have their education in Andhra School. Okay, many of you know where Andhra School is in Kolkata. So these are the linguistic. Okay, so this is a linguistic school. I have already talked about the religious. So even in linguistic, regional based, they also have it. Okay, so they can administer, they have their own syllabus which is being definitely being followed either under CBSE or ICSC, that is, or West Bengal Government Board. So these are the things. The syllabus has to be approved, but the way of education, the way of their schools, or every school has a different culture. So that culture can be defined by the administration, which may be based on linguistic, or it may be based on the religious. Okay. Next, these are the things which are being done for the rights for the minorities to establish any sort of education. So it's basically Article 30, not Article 29. Okay, I will just, when I'll share the slides with you today, I'll just make sure that this is being corrected. Okay. Next, after Article 30, we jump to Article number 32 to Article number 35. Okay. So Article number 31, I have already told you, Article 31, it has been struck off from the Indian Constitution, and this was the right to property. We will talk about where is this right as of now. So now, in Article number 32, we will talk about writs, various types of writs, and these are about constitutional remedies. Article 33, Article 34, and Article 35. These are the military laws, and these are only administered, or these are only followed when the martial laws are imposed. Okay, so we are not going to talk about these articles 33, Article 34, Article 35. We will only talk about Article number 32 in this particular our chapter. Okay, so now we will talk about writs, various types of writs, and the scope of it. So basically, what is writ? What is a writ? You must have been having this question in your mind. Writ means any kind of order. Okay, writ means any kind of order and anything issued under any authority, that is called writ. And in this sense, Article number 32 gives Supreme Court, and Article number 226 gives High Court to issue writs. Of which writs they can issue? Writ of habeas corpus, writ of mandamus, writ of prohibition, writ of certiorari, and the writ of quo warranto. So these writs are very, very important. Okay, you need to understand what are the writs. Okay, so yes, we will talk about writs of habeas corpus in our this slide. So what is habeas corpus? Habeas corpus literally means to have the body of. That means to be produced before court. Okay, writ means to have the body literally. That means if any person is being arrested or being detained, he or she should be produced in front of the court within, I have already said, within 24 hours of the arrest or detention, excluding the time to travel. So this is habeas corpus, and this is about constitutional remedy, that anybody who is being arrested is being produced before the court. Next is, this kind of writ is issued to protect personal liberty of a person, of any individual. Yes, personal liberty, that means arbitrary action by the state or the private individual out of any frustration or out of any kind of sudden, if they are feared, the authorities get feared of some person, and suddenly that person is being arrested without any notice or without anything, then he has got the right. He has got, already I have talked about the right about protection against arrest and detention, which we had talked in the article number 22. Okay, we are talking about Article 22. Article 22, that is the article which says that any person cannot be arrested without any warrant, and if anybody has to be arrested, then he has also got this right, that is the writ of habeas corpus, that court orders to have him produced in front of the law, front of any district magistrate or any court. the aggrieved person can even claim compensation if the charges are proved wrong against that person. Okay, so aggrieved person can definitely claim for compensation. Okay, so this is about the writ of habeas corpus. So I am repeating once again, writ of habeas corpus means to literally have the body of, that means to be produced before the court. Just remember, habeas corpus means to be produced in front of the court physically. The person should be present in the court, and that is habeas corpus. Okay, I think I have made myself clear. Next, we are talking about the writ of mandamus. That means, which literally means we command. We command. That means a command has been given against any public authority, even court, by the higher court. Okay, so these are the to do, that means they are being forced to do a particular work that was ought to be done but was not done in time. So writ of mandamus, if we talk about writ of mandamus, is issued against any public authority or an officer or even courts to do or to compel that particular organization or a person to do a particular work which has to be done. That means if we talk about, that means a case is being going on, and the lower court, due to certain lack of evidence or certain things which happen in our legal system, a person is being allowed to roam about freely. Okay, and that there has been no detention order being produced or asked, and after the case goes to the next higher court, then the court, if find that there are certain problems with the decision of the lower court, they force them to issue a writ. By issuing a writ, that you have to put him under detention or house arrest, whatever it is. Or sometimes it happens that any harsher punishment or harsher things which has been given by the lower court, and the higher court believes that this should not have been done, then again the vice versa also may be happening. So that means the higher court has the authority to guide or to issue writ against the lower court and say some things has to be done. This writ cannot be issued against president, governor and chief justice of a high court acting in judicial capacity. Okay, so they should not be giving writs against the president, the governors and the chief justice of a high court for acting in judicial capacity. And the writ of mandamus cannot be issued against a private individual or a body. Means the authority, only the authorities like police or like the civil servant or the office of the DM or whatever the persons who are an authority in a state or in a particular place, against them only the mandamus is being issued. It is not against any private individual, not against any individual or an individual person. So habeas corpus was for the individuals. Mandamus is not for the individuals. It is only for the authorities, maybe a government organization, maybe the police department, maybe the district magistrate's office, or the office of the superintendent of the police. These are the places where the writ of mandamus are being addressed. Okay, can be put on. Next, we are talking about prohibition. Prohibition obviously means to forbid. This kind of writ is again issued by higher courts to the lower courts when the latter exceed their judicial authority. That means if somebody issues certain kind of writ or certain kind of judgment which is not in the capacity of the lower court, then the higher court says that you have no authority to issue this judgment. It is let us handle it. let us handle it. Okay, basically this objective is to limit the jurisdiction. This is basically to limit their respective jurisdiction. That means they cannot cross their line for certain issues or certain judgment. So these are the things which prohibition tells us to do. Okay, so again, it can be issued only against judicial and quasi-judicial authorities. It cannot be against administrative authorities or legislative bodies or private individual bodies. I think now you are getting it. Habeas corpus was for the individuals. Mandamus was for the public authority. Prohibition is only for the courts, the lower courts. Okay, prohibition is only for the lower courts. I think now you are getting it. Again, I'm just repeating once again. Habeas corpus for human beings or the individuals. Mandamus for public authority. Prohibition for lower courts by the higher courts. Okay, I think now it is clear. Next, we move on to certiorari. Literally means to be certified. And this writ is issued to quash the order of a lower court or decision of a tribunal in excess of its jurisdiction or lack of jurisdiction or error of law. This is again against the whom? The certiorari are also issued against the judicial authorities. Okay, lower courts once again. Let us say, for example, a person is being charged for robbery and the lower court has given that he should be hanged. He should be hanged till death. Well, this is a very harsh statement. So the higher authorities or higher court can definitely say that you cannot give him. This is an error of judgment. This is an error of law. He has just done robbery. You can give him a maximum period of 3 to 4 years in prison or maximum 7 years in prison because he hasn't, maybe it is a possibility that he has not killed anyone. So you just cannot hang him for a petty robbery which he had committed. Or maybe there is a problem which is outside the jurisdiction area of the court, but still they have given certain decisions based on that case. And then again, the higher court comes in and says that it is outside your jurisdiction area. You should not have given this judgment and you should have just transferred or just pass on the case to the higher court for a better judgment. So this writ, certiorari, to be certified, can be only used for the judges, for the court of laws. Okay, but unlike prohibition, this is a preventive, which is only preventive. Certiorari is both preventive as well as curative. I said in error of law, error of judgment, they have rectified. So if they are rectified, it is curative. If they are saying that this is not correct, you should give something different, that is preventive measure, which is a certiorari, which is actually in prohibition. So prohibition and certiorari basically is very, very similar, but there is just a small difference, that certiorari is a preventive measure, whereas prohibition is a preventive measure, whereas certiorari is both preventive as well as curative. Okay, so this is about the certiorari. Next, we will talk about quo warranto. Quo warranto literally means by what authority or warrant. Means it is an authority, it is an authoritarian body, and this kind of writs are issued on violation of fundamental rights. Okay, these are the issues. These are the basically these are for the fundamental. There is a fundamental rights problem arises. Quo warranto are being enforced by the court of justice. This kind of writ is issued to ensure that the person holding any public office is qualified to hold the office. That means a public office. Let us say he is a district magistrate of our district. Is he eligible maybe because of his certain decisions, it may be said that he may not be qualified to become a district magistrate. So that will be the time you can ask question, is he the correct person to hold the office? Or maybe in any kind of this thing, means it may not. And one more thing, okay, one more thing you need to understand, that it is not necessarily that the person has to be aggrieved. Means it may be a possibility that there is no case against him. Maybe district magistrate has ordered something like there should be a complete lockdown in this particular area, and that was a bit tough decision. So court can definitely ask the question, is it the correct answer, is it the correct decision given by this person? Maybe there is a case which is going on between some other parties, and they said that the district magistrate has given us such and such order, so, and it was a harsh decision. So that will be the time that court can will be questioning whether he is eligible to hold the office, or whether he has understood the case basically, so that and given this particular decision. Or superintendent of police, or a normal police station says give some kind of decision to maintain law and order. So that will be the time, if it is found that this is something wrong, the court will definitely ask question, and that is not necessarily against the same person who is being accused. It's not necessarily that he is an aggrieved person. So this is about the mandamus, sorry, it is about the quo warranto. So I believe that unlike the other four writs, this writ is a bit different. In the earlier writs, it was against certain persons or certain organizations who have done something wrong, or they are and it is about but here the person may not be directly involved in any wrongdoing, or may not be aggrieved, and this kind of asking a question can be done by issuing the writ of quo warranto. Okay, so this is all about article number 32, and for this particular reason, article number 32 is being said as the heart and soul of our Indian Constitution, because these are constitutional remedies. These are the rights for the constitutional remedies, and if we think that the constitutional procedures are going against me, and it means the persons who are dealing with the laws and they are modifying the laws, so that will be the time when I can seek justice, or the court can issue the writs, so that the justice can be enforced upon. And this is basically, we are talking about the writs. Okay, now in the I'm just going back about the writs. One is under article 32 and one is under article 226. Okay, so article number 32 is dealing with the writs issued by Supreme Court, and article number 226 discussed about, so what is the basic difference between the jurisdiction of Supreme Court and High Court based on regarding the writs, if we talk about. So I have already talked about article 32 and article 26. Now article number 32, that is the Supreme Court writs, is limited only to the enforcement of fundamental rights. Enforcement of fundamental rights, that means fundamental rights has to be enforced. The high courts can issue them also for other infringement of constitution outside the fundamental rights. Means if any kind of infringement occurs outside the constitution and fundamental rights, for that high courts can also issue writs. Supreme Court, being the apex court of the country, can issue writ for whole of the country, whereas the high courts, as its jurisdiction is only fixed within the state or the areas covered under the high court, the writs can be issued by a high court in its jurisdiction only. Okay, so these are the things which are difference in the writs issued by the Supreme Court and the writs issued by the High Court. Let's move on to the next part. As I said about the article number 31, where is the present situation or present thing about or present position of the right to property, which was once upon a time article number 31. Okay, now it is after the 44th Amendment Act of 1978, which repealed article number 19(1)(f), and 19(1)(f) means it says that which is guaranteed to every citizen right to acquire and hold, dispose of property. Okay, and article 31 says that it guaranteed every person, citizens or non-citizen, right against deprivation of the property. So article 19(1)(f) said about the acquisition of the property, and article number 31 says about deprivation of his property. So from article number 44th Amendment, which repealed article number 19(1)(f) and as well as article 31, and inserted a new article in 300A of part 12 under right to property, and it says that the property is not a fundamental right but a legal constitutional right, that if possible a person can definitely own a property. But again, there is another catch in it. If the state thinks that the property has to be confiscated for some developmental activities, remember, note this down, remember, means there is a thing which I'm stressing upon, for the developmental activities, then proper compensation has to be paid to the aggrieved person by the state. That means if any company or the state government wants to do certain kind of construction activities in my property, upon my property, and wants to get hold of my property, I should be given proper compensation based on the present market rate, so that I am not facing a loss. I don't face a loss, and because of the arbitrary or a normal decision by the state government. Like you see, whenever the agricultural lands are being taken by certain companies, private or public sector companies, the persons who hold the rights to those lands are getting compensation. Sometimes the farmers and other people say that the compensation is not good enough, and they start doing agitations, and these are the things which are mentioned under article number 300A, in which if a person feels that he is not getting proper compensation for the land which are being taken up, or the property which are being taken up by the government, I can definitely go to the court of law and seek justice and seek proper compensation also. Okay, so this is the present position for this right to property, which was once upon a time mentioned in article number 19(f) and as well as article number 31, which is now does not exist anymore after the 44th Amendment of 1978, which was done by the Janata government headed by Morarji Desai, who was the Prime Minister at that time. Okay, so now we will very quickly cover the directive principles of state policy in our part number 4. Okay, so part number 4 we will talk about Dpsp. So Dpsp are enumerated in part 4, which comprises of article number 36 to article number 51. These are the stuffs which are being borrowed from the Irish Constitution of 1937, who earlier had copied from the Spanish Constitution. And DPSPs are in a nature which gives direction to the state, and the state is expected to incorporate them in policy framing and laws. That means these are the instructions to the states, and the state is expected to follow those things, follows those directions given by the constitution of our country, and at the same point of time they make certain policies and laws so that those directive principles of state policy can be implemented. Okay, so if we talk about the features, these are the, I have already talked about, these are the instructions, recommendation to the state legislative, executive and administrative matters. And DPSP, if we talk about, these are instrument of instructions. And at one point of time, as we have taken a lot of features from Government of India Act 1935, so these DPSP in those days were known as instrument of instructions which were to be followed. Later on, it became DPSP, and these are non-justiciable in nature. That means if a person feels that the state is not following this particular DPSP or directive principles or instructions, they cannot go to court and forcibly say that this has to be done, this has to be incorporated. They cannot do that because it is not justiciable. So now the classification of DPSP can be done in three parts. One is the socialist principles. I'm just changing the color. One is the socialist principle, one is the Gandhian principle, and one is the liberal intellectual principles. And these are the articles which are dealing with these particular stuffs. Okay, so I will be just talking in brief. About these particular articles, but not in a very detailed manner. I'll give you the handouts. I will give you the material of this particular chapter at the end of this class. By tomorrow or day after tomorrow, I will just prepare the notes and I will give you to them. Okay, in the Google Classroom. Okay, let's talk about these socialist principles. That means article number 38, 39, 39A, 41, 42, 43, 43A and 47. So if we talk about the socialist principle, they lay down the framework of the democratic socialist state and aim at providing social and economic justice and set paths towards the welfare of the state. So that means a welfare state has to be there, a socialistic approach has to be there in the democratic socialism which we follow. In both the social and as well as economical justice, there has to be certain socialist principles. That means everybody is equal in the eye of laws. So this is about your socialist principles. And if we are talking about article number 38, article 38 says to secure a social order and promotion for the welfare of the state. So this is about article 38. Article number 31 says the socialistic nature. Now you see article number 39, it says about equality in pay at work, preservation of health of the workers and children against forcible abuse, adequate means of livelihood, prevention of concentration of wealth and means of production. So you see, these are the terms, they are socialistic in nature. Socialism is being approached over here. You see, prevention of concentration of wealth. A person cannot have immense amount of wealth, that has to be distributed to some extent. That is a socialistic manner. Equality in pay for equal work, that is socialistic in nature. Equal justice and free legal aid to the poor, that is a socialistic principle. Right to work, right to education, right to public access of the public properties, and also seek assistance in case of unemployment. These are socialistic principles. And for the same, as you see, I have talked about unemployment. We have an employment exchange which is now converted into National Career Portal, NCP, where you can say that, okay, I am a graduate or I am an undergraduate and I have these skill sets. Please give me a suitable job. So National Career Portal is taking care of that, and that is based on the directive principles of state policy. The National Career Portal, it was not existed, may say around 3 to 4 years back, around 10 years back. It is a new feature which has been implemented by our central government. Okay, so there are a lot of things, like you see, there are certain for employment, if we talk about, or for a business setup, the government on invariably every year lays down certain laws, certain schemes, so that the people can be benefited. So these are under socialistic principles of our this particular means directive principles, DPSP, under socialistic principles. Okay, and now we will talk about the Gandhian principles. Gandhian principles is basically a reconstruction enunciated by Gandhi during national movement. So Gandhi basically said that means all the dreams of Mahatma Gandhi are and his ideas are included as DPSPs under the Gandhian principles. Like you say, Gandhi initially said when we were on a verge of getting independence that the government should be decentralized. There should be panchayats in every village which will take care of the law and order of the village. But well, he was not in favor of a central strong government. But yes, India had the central government, a strong center, as well as a less stronger state. But if we talk about the Panchayati Raj or Panchayats, that was also implemented because it was based on the principle of Gandhi. Gandhi said to improve cottage industries. So cottage industries, khadi industry, they were also promoted. And this is about our Gandhian principles. If you're talking about, Gandhi also said that there should be a prohibition in intoxicating drinks and drugs which are injurious to health. And you see, not all states, but there are few states like the state of Bihar, they have already banned the consumption of liquor and tobacco in public as well as and the sale of alcohol is also being banned in various states. In the northeastern states also, they have banned the sale of alcohol or liquor because it is based on Gandhian principles. But that means, you see now, few states have done it, but that does not mean that every state has to do it. Because if I feel that in our state the consumption of alcohol is much more and we should be banned, if I go to the court of law, they will say that this is under directive principles of state policy and we cannot enforce it upon the state government unless state government takes a mandate on it. They cannot do it. It is not justiciable. So I have just talked about few things. These are the Gandhian principles. Gandhi principles also said that slaughter of animals, cows and calves, should be banned. So in Uttar Pradesh, you see, the cow slaughter has been banned by the Yogi Adityanath government. So these are the principles against it. These are the DPSPs which, if the government, state government feels they should follow it, they will follow it, but they cannot enforce it upon everyone. Next, we are talking about the liberal intellectual principles, and this category basically says about liberalism in our society. Liberalism means we should have a uniform civil code for all the citizens. There should be free and compulsory education for the children until they complete the age of 14 years. You see, initially it was a DPSP, later on it was made a fundamental right. We should promote international peace, and for that we are every year we are sending our UN peacekeeping forces so that they can go and create international peace. Especially if we talk about the country of Sierra Leone, we talk about South Sudan, all these countries where UN peacekeeping forces go, Indians also participate in this particular thing. We should be protecting our environment. We should be protecting and safeguarding our wildlife. These are also our liberal intellectual principles, and these are also our DPSPs. So basically, in nutshell, DPSPs are the instructions given by the state government, by the constitution, to the government, to the state and the center, so that they can follow and implement in their lawmaking process. Now you may have understood all the things which I have explained and how they are being implemented in the lawmaking process. So now if you're talking about implementation of DPSPs, there are certain very important things like Manrega, Mahatma Gandhi National means Rural Employment Generation Program, and these enables the commitment to the livelihood to all, and this is one of the socialistic principles. Okay, if you're talking about Sarva Shiksha Abhiyan, Anganwadi program, maternity related health schemes, these are also promoting the welfare of the women and children, and these are also socialistic approach. We talk about cottage industries, handicrafts, khadi, and if you talk about other things, these are the Gandhian principles. So basically implementation of DPSP is going on pretty good in our country. And there are certain distinctions between DPSP and fundamental rights. The fundamental rights provide a foundation to the political democracy, whereas DPSP basically says about social and economical democracy. So yes, we follow democracy, we follow social as well as economic democracy, but the political democracy is being controlled by the fundamental rights. They lay out the foundation, whereas DPSP says about economic and social democracy. Fundamental rights are justiciable, whereas DPSP are not. DPSP are not restricted to any single part of the constitution, whereas fundamental rights, I have talked in FR, they are only in part 3. DPSP is dynamic in nature, whereas FR is static in nature. So all these things you are very well understanding now. When you will be reading through this whole chapter once again, you will definitely understand what are these features which I have just spelled out. Now in a very short, I will just tell about fundamental duties. These are enumerated under Article 51A and inserted after the 42nd Amendment of 1976 and taken from erstwhile USSR, and they were incorporated to the Constitution by Swaran Singh Committee. And these are our fundamental duties. Just go through it. What are the things which I have already talked about? Few of the fundamental duties in our first year classes. When you were in first year, I have talked about certain principles like we should respect our flags, national flag, we should preserve our rich cultural heritage, we should defend our country and render our national services when called upon. And this happened in the year of 1962 when the volunteers for policemen, they were asked to participate in the war. To cherish and follow noble ideas. Okay. Then we have already talked about this. We talk about developing scientific temperament. Yes, we have mission to Mars. We have introduced right to information. Okay, so we have to protect and improve and have compassion towards national environment, forests, lakes and rivers. And we have various characters which we have taken upon. Tigress Avni, and there is another tigress now which is very famous, the Machli from Madhya Pradesh, Kanha National Park. Okay, so we are also moving towards skill education. We are also and the parents and the guardians, they are also being entrusted that they should be sending their children for education from the age of 6 to 14. So these are basically of our fundamental duties. So with this, we come to an end of this chapter, and similarly, we will also as we come to this end of our first module, I will be giving you the notes of the first module to you people so that you can go through it, and we will start with our second module in our next upcoming class. Okay, so I will be making the attendance link live so that you can give your attendance now. Okay, thank you and have a great day ahead and stay safe. Okay, thank you.